Hi friends, good evening. Welcome everyone for today's session on stay of demand under Income Tax Act. So a very practical topic, and also which is relevant, wherein after your return of income being filed, when you are faced with an assessment, and basis that when you receive a demand notice and you prefer an appeal against that demand, this aspect becomes very relevant as to how you can take benefit under the Income Tax Act by not making the payment or making a some percentage of payment of your tax demand. So today's discussion would be entirely on this aspect. Before starting, would like to acknowledge the effort of Subhash in making this presentation ready. Legends used, similar to what we have seen earlier: AO, Assessing Officer; CIT, Commissioner of Income Tax, or CIT Appeals would be Commissioner of Income Tax Appeals; ITAT, Income Tax Appellate Tribunal. The schema for the evening: stay of demand, appellate procedure in brief, the application for stay of demand, parameters, what are the various parameters for granting stay, prepayment for stay, is prepayment fixed, some other conditions while granting or while making the application for stay, application for stay of demand made to CIT Appeals as well as to ITAT. Stay of demand, in a layman language, a postponement of recovery of demand during pendency of appeal. Demand is payable under once a notice is issued under Section 156, which needs to be paid within 30 days. So either the demand needs to be paid or an appeal needs to be filed within 30 days of the receipt of notice under Section 156. Stay of demand, however, if the assessee has opted to raise an appeal to the appellate authority, so in case an order has been passed by AO, the appeal would be to the Commissioner of Income Tax Appeals, or if at all it is passed by CIT Appeals, it would be with the ITAT. Then, in such a scenario, there may be a possibility of granting stay on recovery of demand as long as the appeal with the appellate authority remains disposed of. For this purpose, SSD files a letter along with relevant enclosures for grant of stay of demand during the pendency of appeal. So, what exactly the procedure we'll see later, friends. Appellate procedure in brief, as I've mentioned earlier, order passed by AO determining the liability of amount of taxes along with penalty and interest to be paid. Notice under Section 156 is served. Appeal made to Commissioner Appeals under Section 246A. Commissioner can confirm, reduce, enhance the penalty or pass order as powers conferred in Section 251. So this is the first appellate authority. After the order has been passed by Commissioner Appeals, the appeal can be made to the appellate tribunal. Order has been passed by appellate tribunal under Section 254. Against the order of a tribunal, the appeal can be filed in High Court only if there is a substantial question of law and there is no question of fact. Appeal, the stay of demand application can be made to assessing officer or to commission appeals as the case may be. And in case the appeal is pending with ITAT, the application can be made with appellate tribunal. Appeal made to if the appeal is being made to CIT Appeals, application can be made to AO. Also, CIT Appeals has the powers to grant a stay if AO rejects the application for stay of demand. CIT Appeals also has the powers. We'll see later the relevant provisions for this and the judicial precedents regarding that. When appeal has been made to ITAT, application can be made to ITAT again for stay of demand. Within 2 weeks, the application needs to be disposed of, whether acceptance or rejection. There are three parameters for granting stay of demand. There has to be a valid reason in appealing at a higher level. So it cannot be a no-brainer facts or a no-brainer case wherein the assessee is knowing or the facts are very much clear, or which is not in favor of assessee, and also it is a very genuine case of department or revenue winning that. In such a scenario, if the case is very direct, and the authorities, while granting the stay, they may have reservation in granting the stay of demand, wherein the case is very direct. Financial stringency, in case one more aspect which needs to be seen is whether there would be any financial hardship if the amount is being required to be paid by the SSE. Balance of convenience. So it has to be seen that the loss cost to this would be relatively greater if the stay is not granted. So these are the three parameters which was which was provided in the case of Mrs. Kannambal versus Income Tax Officer 1-1 Tirupur, and also upheld by Sriram Finance as the Principal Commissioner of IT. So this was the rationale given for granting the stay. Prepayment for stay of demand, there has been a history, friends. Earlier it was the entire amount, but then it has been reduced. So in 1996, while granting stay, field officer may require the SSE to offer suitable security, bank guarantee, etc., and or require the SSE to pay a reasonable amount. The amount reasonable needs to be paid. How much it was not defined. In 2016, through memorandum of instruction, it was confirmed that payment of 15% of disputed demand needs to be paid. Uh, uh, Friends, please be clear here. There is an instruction which has been given by an office memorandum. So this is nowhere mentioned in the Income Tax Act that 15% or 20% needs to be paid. It all depends on at the discretion of the authorities. But standard in 2016 was 15%. 2017 it was increased to 15 to 20%, and now wide amendment Finance Act 2020. If the appeal is been pending at the tribunal level and the stay of demand application has been made at the tribunal level, along with 20%, another 20% needs to be paid. So earlier it was only 20%, entirely 20% of the demand number, but now when you are making an appeal to ITAT, 20 plus 20, 40% needs to be paid as an amount upfront for the purpose of stay of demand. Is a 20% prepayment fixed? As I've said, friends, there is no provision or sections in the Income Tax Act which confirms this 20% amount. But however, uh, in the following two cases, the AO referred the matter to the administrative principal commissioner of income tax or commissioner of income tax, who, after considering all relevant facts, decided the quantum of demand to be paid. The payment of lump sum amount higher than 20% is warranted where addition on same issue has been confirmed with judicial precedents or based on a credible evidence collected in a search or a survey operation. So if these are the cases, the 20% amount can be more. So the authority can demand more amount for granting stay. Payment of lump sum amount lower than 20% is warranted where addition on the same issue has been decided in judicial precedent in favor of or there has been a judicial precedence which is favoring the case of the assessee. Hence, in such a scenario, amount less than 20% can be allowed or can be made. 20% prepayment is applicable only at the level whereas the courts may demand a further payment of 20% of the outstanding demand. This was again a ruling in the case of Bright Packaging P Limited versus ACIT. It's a Karnataka High Court ruling in 2019. But now, as we have seen, friends, as per the amendment in Finance Act 2020, where it is ITAG, then additional 20% can needs to be paid along with the original 20%. Other conditions, the AO may require or the authority may require an undertaking from assessee to cooperate in the early disposal of appeal. The AOA may reserve the right to review the order passed after expiry of reasonable period, say 6 months, or if the SSE has not cooperated in the early disposal or where a subsequent pronouncement by a higher appellate authority or court alter the above situation. So the authority may have the right to review the order passed if the SSE has not cooperated in the early disposal or where a subsequent pronouncement by a higher appellate authority was made, which alters the current situation. Authority also reserves the right to adjust refunds arising against the demand to the extent of the amount required for granting stay and subject to the provisions of 245. So even this power is available or this condition is also applicable while granting stay of demand. Application for stay of demand made to CIT appeals, as we have seen, friends. For CIT appeals, there is no a specific mention in the act that CIT appeals can grant stay. But however, in the case of Paulson's Litho Works versus Income Tax Officer 1994, it was held that even though specifically it is not mentioned, where AO rejects, Commissioner of Appeals will have or does have a general power under Section 251 to grant the stay. So, in case practically if AO appeal is pending with the CIT appeal, then assessing officer is asking for demand and he is not accepting your stay petition, you can approach the Commissioner of Income Tax Appeals himself or herself and ask for the stay of tax demand. He would, it is well within his power to grant you the stay if the case is a legit case. Application for stay of demand made to ITAT, again tribunal cannot however grant stay beyond a period of 180 days. So a tribunal has the power only to grant a stay of 180 days, which can be further extended up to 365 days a year. So friends, practically say CIT appeals has passed again an order which is not favoring you, and you have preferred an appeal to an ITAT. So in such a scenario, 20% which has been paid, along with that another 20% wide amendment of Finance Act 2020, so 40% needs to be paid. After making the payment of 40%, the stay can be granted by tribunal, but that also can be extended only up to 1 year, that is 365 days. After the expiry of 365 days, even though the appeal is disposed of or not, what is pending with the High Court, the entire amount needs to be paid. So practically up to 1 year. So if tribunal does not dispose in up to 1 year after the case has been received by it, there may be a possibility that you have to pay entire amount even though the case is pending with the High Court or not. Along with the stay of demand application, the following details also needs to be mentioned. Short facts regarding the demand: result of the appeal filed before the CIT appeals, exact amount of demand, date of filing the appeal, any application for stay that was made to the revenue authorities concerned, brief reasons for seeking stay, whether the applicant is prepared to offer security, and if so, in what form. Prayers to be mentioned clearly and concisely shall be supported by an affidavit along with the fee of rupees 500. So when it is ITAT, you have to pay a fee of 500 rupees along with the application for stay of demand, and these detail needs to be mentioned. Those specifically not provided a similar application along with relevant enclosure would suffice for applying for stay of demand to AO or CIT levels. However, 500 rupees fees is not applicable for at the level of AO or CIT appeals. Conclusion: previously, the field authorities often insist on payment of very high proportion of the disputed demand before granting stay of this. Earlier, as I said, friends, as there is no specific mention in the income tax itself, in Income Tax Act itself, that a certain prescribed percentage of amount needs to be paid while making an appeal. The officers or the revenue department was asking a very high amount. Then, based on the circular passed in 2016 and 17, the amount or the percentage which was arrived at was 15 and then 20%. And now with the amendment by Finance Act 2020, additional 20% in case the appeal is being filed with the ITAT. Instructions are only a thumb rule and cannot substantiate the basic tenets to be followed in the consideration of stay petition. As I have said friends, if a case is genuine, there has to be, and if at all say a judicial precedent is backing your case, the amount can be less than 20%. But again, if a judicial precedent is against your case, and again in your case in earlier years there has been a uh, passing of order which or confirmation of order which was against you, such a scenario the amount can be more than 20% as well. So these were some of our thought, friends, on the stay of demand provisions in income tax.